This is a review of the most interesting and important cases decided by the Supreme Court in its October 2014 term. The 2014 term brought some controversial issues before the court. The court didn't back away, but dealt with them decisively, although in many cases by a sharply divided majority vote. Few of us will ever practice in the Supreme Court, but we all need to know what it is doing. Their decisions affect our practice, our country, and our lives. One of the most high-profile and important decisions of the October 2014 term was Obergefell v. Hodges. This case resolved the issue of same-sex marriage. It involved 30 individual plaintiffs and 4 states. The issue of same-sex marriage had been argued in lower courts, state legislatures, pulpits, and living rooms across the country for years. The High Court finally met the issue head-on and ruled that the 14th Amendment requires a state to license a marriage between 2 people of the same sex and to recognize a marriage between 2 people of the same sex when their marriage was lawfully licensed and performed in another state. The majority noted that prior decisions had established that the right to marry is protected by the Constitution. The court had previously invalidated bans on interracial marriages and marriages involving prisoners. The majority also noted the legal and social evolution of gay rights. In 2003, for example, the court had overruled an old decision which had upheld a Georgia law which made certain homosexual acts criminal offenses. In 2012, the Federal Defense of Marriage Act was struck down. In that decision, the court agreed that the right to regulate marriage had been historically reserved to the states, but ruled that the state interest is subject to constitutional guarantees. That decision was based on the liberty interest in the Fifth Amendment. In Obergefell, the majority conceded that marriage has historically been seen as a union between 2 persons of the opposite sex. Writing for the majority, Justice Kennedy explained that the history of marriage included not only continuity, but change. Changed understandings of marriage, he wrote, are characteristic of a nation where new dimensions of freedom become apparent to new generations. The majority identified 4 principles and traditions which make marriage by same-sex couples a fundamental right. First, prior cases recognized the right to personal choice, in race, for example. Second, marriage is a 2-person union unlike any other in its importance to the individuals. For example, the court had ruled in 1965 that married couples had a right to use contraception. The third principle was safeguarding children and families. Without the recognition, stability, and predictability that marriage offers, children will suffer. Banning same-sex marriage harms and humiliates the children of these couples. The fourth principle was that marriage is a keystone of the social order. There is a constellation of benefits states have linked to marriage. The court held that the right of same-sex couples to marry was guaranteed not only as a liberty interest, but also as a guarantee of equal protection. Justice Kennedy said new insights and societal understandings can reveal unjustified inequality within fundamental institutions that once passed unnoticed and unchallenged. He noted that the court had invoked equal protection principles to invalidate laws imposing sex-based inequality on marriage and confirmed the relationship between liberty and equality. The majority considered waiting for legislative change, but concluded that individuals who are harmed need not await legislative action before asserting a fundamental right. Chief Justice Roberts wrote a dissenting opinion joined by Justice Scalia and Justice Thomas, in which he said the court is not and should not try to be, a legislative body. Under the Constitution, judges have the power to say what the law is, not what it should be. He called the majority view disheartening. He predicted that, quote, stealing this issue from the people will for many cast a cloud over same-sex marriage, making a dramatic social change that much more difficult to accept, close quote. Justice Scalia wrote separately, calling the decision a threat to democracy. The court, he said, ended the public debate over same-sex marriage, which had displayed American democracy at its best.
I agree with the majority. The unfortunate part is that it took so long. These are families, and the families have children. And in the United States, we benefit from families, from the cohesiveness of the parents, the children, and they're being proud of being a family in front of other people. We've always really not respected people that have gay parents or an unusual family dynamics. In this case, you had two men. You had Obergefell, and you had a man named Arthur. And John Arthur was extremely active. They had been a couple for almost 20 years. And at one point, he had difficulty walking, and no one could really figure out why. So finally, they determined he had ALS, or Lou Gehrig's disease. He was unable to walk up the aisle. And since they lived in Ohio, they couldn't marry there at all. They got on Facebook, and they were able to go ahead and get enough money to fly a private jet all the way to Maryland, where they could marry each other. And the minister came on the plane and made them a couple. Unfortunately, 4 months later, he died. And Obergefell was unable to be on the death certificate as a spouse. And that started this case. Now, there are almost 40 plaintiffs involved in this case, but that's a story of how it evolved. And that's why we needed this case. It was extremely important.
The dissenters would argue, and did argue, that this is a matter that's best left to the states, that it's such a controversial decision, that it was right in the middle of the public debate around the country, as Justice Scalia said, and the court ended that public debate when it made it a federal constitutional issue. And so the Chief Justice and others who dissented would say, we should have left this to the public forum, we should have left this to the states. Why would that have been a bad idea?
There was no cohesiveness. Even if you left it to the states, there were 30-some states with all differential laws. So you couldn't go to one state and have your marriage sanctioned and go to another state and have it recognized. And that's what happened to these two gentlemen from Ohio. They had to go to a state where they could be married. Unfortunately, they went back to Ohio, and Ohio didn't recognize the marriage. Now, the only way that you could have had cohesiveness is if this had been a federal law or if it had been rendered by the Supreme Court. And Scalia was right. Why should the Supreme Court make a law for 350 million people? Why couldn't it have been done elsewhere? But it wasn't. And it became sort of a political, religious problem where you had too many dissenters that didn't want to be involved in it, or they had a negative, opinion of what was being done. You had to find somebody with the guts to go ahead and make a proper decision. Now, his dissent was that they shouldn't be doing it. The Supreme Court shouldn't be doing it. But he had a Texas case in which he agreed with single-sex marriage, and that those people should be allowed to go ahead and use Social Security and be a couple in the ordinary means. And and have health insurance and live like the rest of us do with those benefits.
There's an interesting question raised by, I think, the Chief Justice. And I think the thrust of it was that having the court decide this will cause resentment in some people, and that it might even rise to the level of people would be more reluctant to accept same-sex marriage because it wasn't voted on, or it wasn't passed by their state, or they didn't agree with it, and in their eyes the Supreme Court made a law, and that because of that they might be resentful and they might be slower to accept it because it had sort of been, crammed down, for lack of a better word, by the court. Do you think that's going to happen, or do you think that it will actually help people accept it when they realize that our high court has found it to be a constitutional issue that's so important to the country as a whole? Which way do you think it'll go, resentment or acceptance?
Well, statistically, it's shown that it's more acceptable now than it's ever been. Secondly, you have these couples that will now fit more comfortably in society. You used to have a child, and during a divorce, it wouldn't go to the other parent because there wasn't any status that the other parent shared. They weren't co-parenting this poor child. And now they have a home, they have a family, and people see them as such. So I think we've made it a great deal more accepting, and it should be.
In many ways, this decision brings into sharp focus a long-standing debate over whether the court should be activist or deferential to the legislative branch. This was such a divisive issue, the lower courts were at odds with each other. All of the district courts ruled in favor of the petitioners, but the Sixth Circuit consolidated the cases and reversed. As recently as 1986, the court had upheld a Georgia law which criminalized certain homosexual acts. It also implicates the contrast between strict and evolutionary construction. The framers probably would not have envisioned this issue developing at all, and not as a liberty or equal protection interest. But time does move on. Social conventions and attitudes evolve and change. The court has sometimes referred to the Constitution as a living document, and it certainly was so in this case. One of the most intriguing cases of the term was Zavotsky versus John Kerry, Secretary of State. As Justice Kennedy described it, a delicate subject lies in the background of this case. That subject is Jerusalem. Questions touching upon the history of the ancient city and its present legal and international status are among the most difficult and complex in international affairs. The issue in the case was whether a congressional mandate may require the President and Secretary of State, when issuing a passport, to state that the person's place of birth is Israel. Jerusalem's political standing is one of the most sensitive issues in American foreign policy. President Truman recognized the State of Israel in 1948, but that did not recognize Israel's sovereignty over Jerusalem. During the past 60 years, Israel, Jordan, and the Palestinians have all asserted full or partial sovereignty over the ancient city. The United States has not taken sides on this issue, declaring that, quote, "the status of Jerusalem should not be decided unilaterally, but in consultation with all concerned," close quote. Indeed, there is no issue more sensitive to Arab-Israeli negotiations and relations than Jerusalem. In 2002, Congress passed an act that allows persons born in Jerusalem to list Israel as their place of birth on their passport. When President George W. Bush signed the law, he said he understood it to be advisory rather than mandatory. The mere passage of this law, however, provoked protest in the Middle East. The Secretary of State advised diplomats to declare that U.S. policy had not changed, and that we understood the importance of Jerusalem to both sides and many others around the world. Ruling that in the sensitive area of recognition of foreign nations, we must speak with one voice, the court held that the one voice must be the President, not Congress or anyone else. The court conceded that Congress is involved in many aspects of foreign relations, but the recognition power rests exclusively with the President. The act in question was declared unconstitutional. The majority opinion includes a discussion of historical precedent regarding executive power, its origins and limits. It also affirms the importance and the volatility of the Jerusalem conflict. Henry Kissinger said, "If there is to be peace in the Middle East, it must go through Jerusalem."
I think what it does is it's the Supreme Court gracefully pointing out that that is such a global geopolitical hot potato that it is better to leave that alone. And so they might have come to a different result if it hadn't been Jerusalem. But I find it interesting that there are rumblings about moving the U.S. Embassy to Jerusalem, and anything that, the outcry that was provoked by this decision was one that, to say that people around the world are passionate about this is a gross understatement. Where I come from in Texas, when I was growing up, we used to have fighting words. For people in the Middle East, Jerusalem and who controls it and whose capital it is, those are fighting words, and they'll fight over that at the drop of a hat. So it's going to be very interesting to see. But I think the Supreme Court followed the law and followed a proper constitutional precedent. But the undertow of that case was to say the status quo, from our perspective, is the best way to handle Jerusalem, which is that no nation can claim sovereignty over Jerusalem. I hope that if there's a change in that it'll be done with great wisdom and forethought, because it could mean more. And so it'd be very interesting to see what the new administration does with that whole issue.
Conflict between Western and Middle Eastern social customs, beliefs, and biases are not hard to find. Abercrombie and Fitch refused to hire Samantha Eloff, a practicing Muslim, because the headscarf she wore, pursuant to her religious obligations, conflicted with Abercrombie's dress policy. The EEOC filed suit for her, alleging a violation of Title VII. They claimed the employer could not discriminate against her because of her religious practices, when her practices could be accommodated without undue hardship. The Tenth Circuit had reversed a decision for the plaintiff in the district court on the basis that failure to accommodate liability attaches only when the employer is given actual knowledge of the need for accommodation. The Supreme Court reversed, ruling that the applicant need only show that the need for accommodation was a motivating factor in the employer's decision, not that the employer had actual knowledge of the need. The court said the act prohibits certain motives on the part of employers, whether they had actual knowledge or not. The court reminded us that Title VII gives favored treatment to religious practices. The person who interviewed Ms. Eloff found her to be qualified for the job, but was concerned about the scarf. She asked the district manager for guidance, and he told her to not hire Ms. Eloff. Justice Scalia wrote for the court on this one and refused to write in an actual knowledge requirement when the act did not contain one. Conflicts between Muslim and Western culture have made it all the way to the American prison system. This term, the court was called upon to determine whether a Muslim Arkansas inmate had a right to wear a beard. A federal law called the Religious Land Use and Institutionalized Persons Act of 2000 provides that no government shall impose a substantial burden on the religious exercise of an institutionalized person unless the government demonstrates that the burden is the least restrictive means of furthering a compelling government interest. Holt, a prison inmate and devout Muslim, wanted to grow a short beard in accordance with his religious beliefs. The Department of Corrections prohibited beards on the grounds that they could be used to hide contraband, and they could be quickly shaved to disguise identity. The district and circuit courts ruled in favor of the Department of Corrections. The Supreme Court reversed, finding that the prison could achieve its goals of security and identification by other means, which did not deny Holt his religious exercise. The court noted that the majority of states, and federal prisons as well, allow inmates to have beards of the type Holt wanted to grow. The court said the statutory requirement of the prison satisfying its concerns by the least restrictive means is an exceptionally demanding requirement. This was one of the few unanimous decisions of the term, and even so, there were two concurring opinions. Do you agree with the court's decision in that case and how they got there?
I do, and I think what's interesting, many cases that reach the federal appellate courts are either won or lost on a burden of proof issue. And when the Congress enacted the statute that said that you could exercise your religious practice, they put the burden on the government to not restrict that religious exercise unless it was the most minimal means to accomplish a compelling government interest. It's a very high burden of proof. And so when they had an evidentiary hearing and there were different bits and pieces that showed that there was an exception for quarter-inch beards for other prisoners, that safety and security issues could be addressed in an accommodating way, I think the government lost that case because they saw no particular reason to hold hard and fast to the restriction that he could not grow the beard. So it's interesting when a exercise of prosecutorial discretion when you have a U.S. attorney who will continue to prosecute a case. But I thought what was really noteworthy about that case is when you look at the docket sheet, there were dozens and dozens of amicus briefs filed by every major constitutional litigation firm in the country. And so the religious liberty aspect, for me as a Christian, was really important because it might be me wanting to read a Bible versus this man wanting to grow his beard or read the Quran or any number of other religious practices. So I agree completely with it. I think what Congress has done is laid down a really strong marker for the free exercise of religion, even if you're behind bars in a federal institution.
Shortly after midnight, on a cold night in March 2012, a Nebraska police officer stopped a car for driving on the shoulder of the road. The driver said he had swerved to avoid a pothole, and he was only on the shoulder for a short time. The officer ran the driver and his passenger and found no warrants. They explained where they had been and where they were going. The officer decided to issue a warning ticket. He went back to his car, wrote the ticket, walked back to the car, and gave the ticket to the driver, along with his license and other papers. After everything was finished, he asked the driver if he could walk his police dog around the car. The driver refused. The officer called for backup, ordering the men to remain outside the car. The dog alerted, and sure enough, drugs were found in the car. The Supreme Court reversed the defendant's conviction, ruling that absent reasonable suspicion, police extension of a traffic stop in order to conduct a dog sniff is an unreasonable search and seizure. The court made short work of the government's argument that an officer who completes a traffic stop quickly should earn extra time to pursue an independent investigation. The court said a traffic stop prolonged beyond the time needed for the traffic business is unlawful. The critical question is not whether the dog sniff occurs before the ticket is issued, but whether the sniff adds time to the stop. This case is Rodriguez versus United States. It's important to remember that 10 years earlier, in Illinois v. Caballe, the court upheld a dog sniff during a traffic stop, which did not extend the time of the stop. In Caballe, the court held that a dog sniff did not change the character of the traffic stop, since one officer walked the dog around the car while the other officer wrote the ticket. We do not have a legitimate privacy interest, protected by the Fourth Amendment, in avoiding the detection of illegal contraband. Since a dog sniff ostensibly reveals only illegal contraband, it's not a Fourth Amendment violation per se, if it is conducted reasonably. A group called the Sons of Confederate Veterans submitted a proposal to the Texas Motor Vehicle Board asking for approval of a specialty license plate featuring a Confederate battle flag. The board denied the request, and the group filed a federal lawsuit based on the Free Speech Clause. The district court ruled with the board, but the Fifth Circuit reversed, setting up an appeal to the High Court. The Supreme Court agreed with the Motor Vehicle Board that license plates were government speech, not subject to the Free Speech Clause. Texas was not constitutionally required to make the requested plates. The court warned, however, that the government's ability to express itself is not without restriction. Other constitutional provisions and statutes may limit government speech, and the Free Speech Clause itself may limit the government if it seeks to compel private persons to convey the government speech. The analysis in this case was that the plates served the governmental purpose of vehicle registration and identification. The word Texas was placed in large letters across the top of the plate. The state issues every plate and owns the designs. The state maintains control by requiring approval for any specialty plate requested. The plates are not a public forum for speech and discussion where the Free Speech Clause applies. This was a 5-4 decision. The dissent, written by Justice Alito and joined by the Chief Justice, Justice Scalia, and Justice Kennedy, is almost entertaining. The following is a verbatim reading of a portion of the dissent, written by Justice Alito. The court's decision passes off private speech as government speech, and in doing so establishes a precedent that threatens private speech that government finds displeasing. Under our First Amendment cases, the distinction between government speech and private speech is critical. The First Amendment does not regulate government speech, and therefore, when the government speaks, it is free to select the views that it wants to express. By contrast, in the realm of private speech or expression, government regulation may not favor one speaker over another. Unfortunately, the court's decision categorizes private speech as government speech, and thus strips it of all First Amendment protection. The court holds that all the privately created messages on the many specialty plates issued by the state of Texas convey a government message rather than the message of the motorist displaying the plate. Can this possibly be correct? Here's a test. Suppose you sat by the side of a Texas highway and studied the license plates on the vehicles passing by. You would see, in addition to the standard Texas plates, an impressive array of specialty plates. There are now more than 350 varieties. You would likely observe plates that honor numerous colleges and universities. You might see plates bearing the name of a high school, a fraternity or sorority, the Masons, the Knights of Columbus, the Daughters of the American Revolution, a realty company, a favorite soft drink, a favorite burger restaurant, and a favorite NASCAR driver. As you sat there watching these plates speed by, would you really think that the sentiments reflected in these specialty plates are the views of the state of Texas and not those of the owners of the cars? If a car with a plate that says "rather be golfing" passed by at 8:30 on a Monday morning, would you think this is the official policy of the state? Better to golf than to work. If you did your viewing at the start of the college football season and you saw Texas plates with the names of the University of Texas out-of-state competitors in upcoming games, Notre Dame, Oklahoma State, the University of Oklahoma, Kansas State, Iowa State, would you assume that the state of Texas was officially, and perhaps treasonously, rooting for the Longhorns' opponents? And when a car zipped by with a plate that reads NASCAR number 24, Jeff Gordon, would you think that Gordon, born in California, raised in Indiana, resides in North Carolina, is the official favorite of the state government? The court says that all of these messages are government speech. It is essential that the government be able to express its own viewpoints, the court reminds us, because otherwise, how would it promote its programs like recycling and vaccinations? So when Texas issues a rather be golfing plate, but not a rather be playing tennis, or rather be bowling plate, it is furthering a state policy to promote golf, but not tennis or bowling. And when Texas allows motorists to obtain a Notre Dame license plate, but not a University of Southern California plate, it is taking sides in that long-time rivalry. This capricious understanding of government speech takes a large and painful bite out of the First Amendment. Specialty plates may seem innocuous. They make motorists happy, and they put money in a state's coffers. But the precedent this case sets is dangerous. While all license plates unquestionably contain some government speech, for example, the name of the state and the numbers or letters identifying the vehicle, the state of Texas has converted the remaining space on its specialty plates into little mobile billboards on which motorists can display their own messages. And what Texas did here was to reject one of the messages that members of a private group wanted to post on some of these little billboards because the state thought that many of its citizens would find the message offensive. That is blatant viewpoint discrimination. If the state can do this with its little mobile billboards, could it do the same with its big stationary billboards? Suppose that the state posted some government message on these billboards and then, to raise money, allowed private entities and individuals to purchase the right to post their own messages. And suppose that the state allowed only those messages that it liked or found not too controversial. Would that be constitutional? What if a state college or university did the same thing with a similar billboard or a campus bulletin board or a dorm listserv? What if it allowed private messages that are consistent with prevailing views on campus, but banned those that disturbed some students or faculty? Can there be any doubt that these examples of viewpoint discrimination would violate the First Amendment? I hope not, but the future uses of today's precedent remain to be seen. This is a verbatim quote of the dissent written by Justice Alito at 135 Supreme Court, 2254.
I thought it was a fascinating case, and it has a different reason for resonating with me. When I was in high school in Amarillo, our high school mascot that was the Tascosa Rebels, and it was a Southern Confederate infantry hat, and our flag was a Confederate battle flag. And after I graduated from Tascosa in 1973, I think around 1975 or 76, they did away with that Confederate battle flag to much popular outcry, because I can totally relate to people identifying that with slavery and oppression and hatred, as the court said. But I also have a personal history where that battle flag meant nothing like that to me. And so I found it really interesting that they came down the way they did. I loved Alito's dissent with Mr. Scalia and Mr. Kennedy because it was so right on. Their concept of little billboard space, where the state of Texas owns the plate, but they're basically leasing you a small billboard for you to express yourself, I think is the better argument. It's not like the Supreme Court has never gotten anything wrong. I just find it interesting that the minority wasn't able to persuade the minority or majority to their point of view. It seems such a logical thing to me. But those specialty plates are great. It was also intriguing to me because the Texas board that denied the Confederate flag plate in the same hearing granted one for the Buffalo Soldiers, which was the 10th U.S. Cavalry Regiment that was made up of black soldiers. And they just served with distinction in the Indian Wars. Well, there was a commentator in that petition who said that, a Native American who said that he felt about the Buffalo Soldiers having a plate the same way people felt about the Confederate flag. He related to that the same way. So I think when they said it was blatant viewpoint discrimination for the state to choose one message over another, they got that part right. And unfortunately, it was the dissent, not the majority, that expressed that opinion.
Some of the death penalty cases continue to be disturbing because state and even some federal courts seem reluctant to follow Supreme Court precedent. Kevin Brumfield, an intellectually disabled man, was convicted and sentenced to death in a Louisiana court. His conviction was prior to Atkins v. Virginia, in which the Supreme Court prohibited the execution of the intellectually disabled. After Atkins, Mr. Brumfield amended his post-conviction pleadings and requested an evidentiary hearing. The state court dismissed his petition without a hearing and without granting funding for additional investigation on the issue. The federal district court, following Atkins and the evidence, found that he was intellectually disabled and could not constitutionally be executed. The Court of Appeals for the Fifth Circuit reversed, ruling that he had failed to establish a right to a hearing in the federal court. The Supreme Court reversed the Fifth Circuit, finding the state court's ruling unreasonable. This was not surprising since Mr. Brumfield was placed in special education classes at an early age. He was reading at barely a fourth grade level at the time of his trial. He had been committed to mental health facilities at an early age and given antipsychotic medication. He had an IQ of 75. Torrey Grady was convicted in North Carolina of 2 sex offenses over a 10-year period. After serving his sentence for the second crime, he was ordered to appear in court to determine whether he was subject to satellite-based monitoring as a recidivist sex offender. Grady did not dispute that he had 2 sex offense convictions, nor that they made him a recidivist under state law. He argued, however, that lifetime 24/7 monitoring would violate his rights under the Fourth Amendment. The North Carolina courts ignored his arguments, and the High Court took cert. The court reversed the North Carolina courts, relying on U.S. v. Jones and Florida v. Hardinay. In Jones, the court had found a search unreasonable when the government placed a GPS on a suspect's vehicle. In Hardinay, the court found an unreasonable search when the police took a drug-sniffing dog to the area around a suspect's porch. By physically entering the curtilage of the house, they were intruding on a constitutionally protected area. One interesting aspect of the Grady case is that North Carolina argued that the monitoring program was civil in nature. The Supreme Court reminded North Carolina that the Fourth Amendment extends beyond the sphere of criminal investigations and the government's purpose in collecting information does not control whether the method of collection constitutes a search. In finding that the monitoring was a search, the court did not go further and determine whether it was an unreasonable search. Only unreasonable searches violate the Constitution. So the case was remanded for further findings on whether it is unreasonable under the totality of circumstances. This inquiry on remand will include the nature and purpose of the search and the extent to which it intrudes on reasonable privacy expectations. In July 2003, TSA briefed all federal air marshals about a plot to hijack passenger flights. A few days after the briefing, Marshal Robert McLean received a message from TSA canceling all overnight missions from Las Vegas until early August. McLean, stationed in Vegas, believed canceling these missions during a hijacking alert was dangerous and illegal. He contacted a reporter in the media and told him about the cancellation of the missions. After discovering that McLean was the source of the story, the department fired him for disclosing sensitive security information without authorization. McLean challenged his firing, claiming his disclosure was protected as whistleblowing activity, as a disclosure that revealed a violation of law, regulation, or a substantial and specific danger to public health or safety. The Supreme Court agreed with McLean. The disclosure was not prohibited by law, only by a department regulation. An agency may not insulate itself from the whistleblowing statute by simply adopting a rule or regulation that precludes whistleblowing. The court agreed that the confidentiality of sensitive security information should not depend on the subjective judgment of 60,000 TSA employees, but concluded that issue was best left to Congress or the President. Humor always has a place, even in the Supreme Court chambers. While conducting an offshore inspection of a commercial fishing vessel in the Gulf of Mexico, a federal agent found that the ship's catch included undersized red grouper, in violation of federal regulations. The officer instructed the ship's captain, Petitioner Yates, to keep the undersized fish segregated from the rest of the catch until the ship returned to port. After the officer departed, Yates instead told a crew member to throw the undersized fish overboard. For this offense, Yates was charged with destroying, concealing, and covering up undersized fish to impede a federal investigation in violation of 18 U.S.C. Section 1519. That section provides that a person may be fined or imprisoned for up to 20 years if he knowingly alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry in any record, document, or tangible object with the intent to impede, obstruct, or influence a federal investigation. Yates argued that Section 1519's reference to tangible objects includes objects used to store information, such as computer hard drives, not fish. The district court denied Yates' motion, and a jury found him guilty of violating Section 1519. The 11th Circuit affirmed the conviction, concluding that Section 1519 applies to the destruction or concealment of fish because, as objects having physical form, fish fall within the dictionary definition of tangible objects. A divided Supreme Court concluded that a tangible object within Section 1519's definition is one used to record or preserve information. Justice Alito, in his opinion, concluded that traditional rules of statutory construction confirmed that Yates had the better argument. While many of Section 1519's verbs, alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry in, could apply to far-flung nouns such as salamanders or sand dunes, the term makes a false entry in makes no sense outside of file keeping. Finally, Section 1519's title, destruction, altercation, or falsification of records in federal investigations and bankruptcy, also points toward file keeping rather than fish.
I think that story resonated with me because my mom was a fisherman. She actually learned how to fly fish and was very good at it. And so when I read the fisherman story, as your readers or as your viewers may know, Yates was the captain on a 3-man crew out in the Gulf of Mexico, and he was boarded by a fish and wildlife officer who found 72 fish that were a little undersized, under the 20-inch limit. And what was interesting to me is Yates was only subject to a civil penalty, a fine, or a suspension of his fishing license, which would have been pretty onerous because he was a commercial fisherman. But he really made it a lot worse for himself, because after the Fish and Wildlife man segregated 72 fish that were about an inch undersized and told him to keep them that way until he got back into shore, he had one of his crewmen throw them all overboard and replace them with other fish. So he found himself subject to this general spoliation statute, evidence spoliation statute, which only carries, it's a criminal offense, but only carries a 5-year prison sentence. He apparently made everybody up and down the line angry with him for throwing the fish overboard, because they also tagged him with a 20-year criminal offense that it came from the Sarbanes-Oxley legislation to deal with financial fraud. He moved for judgment of dismissal at the end of the case on that 20-year statute, and the judge didn't buy it. Found it was applicable, sentenced him to 20 years on that, 5 years on the other general spoliation statute, and the court never tells us what his fine or his fishing license suspension was. But I'm thankful that he found an attorney that was willing to keep pressing the issue, because it was affirmed at the appellate level, and he went ahead and took it on up to the U.S. Supreme Court. And I'm actually surprised that they granted cert on it, but I think I read between the lines, and I don't know that I have any keen insight, but one of the things the court mentions is that it was 32 months between the time Yates was cited for the original offense and before he was charged with the spoliation charges, the criminal charges. And in that 32-month span, the regulations changed so that the length of the fish to be undersized dropped from 20 inches to 18 inches. None of the fish that he had that were undersized under the original regs were shorter than 18 inches. So I think it's not a no harm, no foul sort of attitude, but I think the justices on the Supreme Court took a look at that and said, subjecting someone to a 20-year prison sentence for what arguably is not big time multi-billion-dollar financial fraud is an inappropriate application of the statute. And so I think in their own way they were saying, this is a little prosecutorial overreach, and we're going to hold you to the letter of the statute.
Much of the regulation of American business and industry is done by federal agencies. Congress passes an act which sets broad policy and delegates enforcement to an agency. The agency often has executive orders to direct its actions, in addition to the actual legislation. But the day-to-day rules are left largely to the agency in many cases. The EPA was given authority to regulate emissions of hazardous air pollutants from certain sources like refineries and factories by the Clean Air Act. The agency may regulate power plants only if it concludes that regulation is appropriate and necessary after studying the hazards to human health caused by power plant emissions. The EPA found regulation of power plants appropriate because their emissions are a threat to public health and controls to reduce the emissions are available. It found regulation necessary because the risks to health were not dealt with by other parts of the Clean Air Act. In reaching its decision, however, the agency refused to consider cost. The cost of business was estimated to be $9.6 billion a year, but the quantifiable benefits to health would be only $4 to $6 million a year. 23 states sought review of the EPA orders in the federal courts. The Supreme Court found that the EPA interpreted the Clean Air Act unreasonably when it deemed cost irrelevant to the decision to regulate power plants. The broad discretion given to federal agencies notwithstanding, the court reminded them that they must operate within the bounds of reasonable interpretation of their statutory authority and direction. The court held that the EPA must consider cost, including the cost of compliance, when deciding whether regulation is appropriate and necessary. This was a 5-4 decision, with the majority opinion written by Justice Scalia. This was a decision very supportive of industry and business. It has far-reaching effects. This decision was based on the interpretation of a specific federal statute, but the rule of reasonable interpretation of whatever mandate an agency operates under has broad application. Michigan v. EPA was decided in June 2015, and it has already been cited in more than 41 cases. In September 2016, a district court reversed a decision of the State Department revoking a passport of a permanent resident who was born in Yemen. Despite the fact that he had given a false name on his application, the revocation was found to be unreasonable because there was not sufficient evidence in the record to support the finding that he had lied about his name. In July 2016, the D.C. Circuit decided a case involving 30 challenges to 3 EPA regulations under the Clean Air Act. The challengers included municipal electric associations, industrial trade organizations, oil and gas representatives, and others. These cases are complex and involve far-reaching legal and policy considerations. The Fifth Circuit decided a case in the summer of 2016 in which the state of Texas and numerous industry groups challenged the EPA's disapproval of Texas and Oklahoma's plans for controlling regional haze. The EPA had formulated its own plan instead. These are hotly contested issues with financial, health, and government policy overtones. There's been much discussion in 2016 about fracking by the oil and gas industry. A Wyoming court set aside a BLM fracking rule, finding the rule an unreasonable expansion of its authority without clear congressional delegation. It's important to remember that agencies like the EPA are subject to the powerful executive authority of the administration. Agency rules can be expanded or limited based on the policy of the administration in office at any given time. And these policies do shape our society and affect our lives. After his wife left him, Anthony Alanis used Facebook to post violent language and images regarding her, his co-workers, a kindergarten class, and law enforcement. He did so under the guise of self-styled rap lyrics. He put disclaimers in them saying the lyrics were fiction and that he was exercising his First Amendment rights. The people who knew him found the post threatening and disturbing. His boss fired him, and his wife sought and obtained a state court protection order against him. His former employer informed the FBI, and they began monitoring his Facebook posts. They eventually arrested him and charged him with transmitting in interstate commerce a communication containing a threat to injure the person of another. At trial, the jury was instructed that the government only had to prove that a reasonable person would foresee that his statements would be interpreted as a threat. Alanis had requested an instruction that required proof that he intended to communicate a true threat. He was convicted, and the stage was set for a battle over the intent or mental state required under this important federal statute. The Supreme Court reversed and remanded, finding that the instruction requiring only negligence was not sufficient to support a conviction. There is no mental state requirement in the text of the statute. The court reminded us, however, that criminal statutes are generally interpreted to include broad scienter requirements, even where the statute does not contain them. It is somewhat frustrating that the court did not say exactly what level of intent is required under this statute. The court only held that negligence is not enough. Federal criminal statutes, Chief Justice Roberts wrote, that are silent on the mental state should be read to include only that state of mind necessary to separate wrongful from innocent conduct. The only guidance was a statement that the elements of the statute are satisfied if the actor transmits the communication for the purpose of issuing a threat, or with knowledge that the communication will be viewed as a threat. The court declined to say whether recklessness would suffice and declined to address First Amendment issues. The Third Circuit affirmed his conviction again on remand, finding that the erroneous instruction was harmless error because the evidence was sufficient to show that Alanis knew that others would feel threatened, probably a knowingly standard. The pervasive use of social media and its continuing expansion makes this an important case. Social media is interstate commerce, and it is good to know that federal law addresses the misuse of this important mode of communication. It is also good to know that the law requires some level of culpable mental state as an element of these offenses. The separation of wrongful from innocent conduct has been an important part of our criminal law from the beginning. Oliver Wendell Holmes said, "Even a dog distinguishes between being kicked from being stumbled over." That said, it's important to stop nuts like Alanis from abusing social media to intimidate and harass others. The Third Circuit was eminently correct in affirming his conviction on remand. He knew what the effect of his tirades would be. And let us not forget that, obviously, a federal jury was not in a mood to tolerate this abuse of an important social media. They convicted even under a negligence standard. While the court did not address First Amendment issues, it's hard to believe that the type of speech engaged in by Alanis would be condoned or protected by our Constitution. This case, perhaps like Obergefell, is an example that the Constitution must be flexible enough to deal with technologies and societal issues the framers could not have imagined. They did a pretty good job, however, of creating a bedrock of ideals that would last with a changing world. This term is a vivid example of the diverse, wide range of issues the court is required to resolve. This term, some of them pulled at the very fabric of our society, challenging emotional and sometimes historical values. It's no coincidence that these cases are reflective of current events. They address problems the country is facing, as they should. Given the nature of the cases, it's no surprise that most of them were decided by a divided court. This is not a bad thing. It's a reflection that the court did not run from the most difficult decisions it was asked to make. Someone had to make them. That is what this court is all about.